My name's Leslie Roberts. I work for a company called Allsop. We're a property company, and I also am the chair of UKAA, and I'm very honoured to be chairing this session today. The panellists have very kindly come up with some topics that we're going to cover, which were itemised in the invite about possession proceedings, managing residents and staff during this time, and moving out of lockdown as a finishing area. So very quickly, just going to ask the panelists to introduce themselves, where they're from, what they specialise in, before we start into the sessions. Anna, over to you.
Good afternoon, everybody. My name's Anna Eiston. I'm a senior associate at Brian K. Leighton Paisner, and I specialise in real estate disputes.
Excellent. Jason?
Hi, I'm Jason Hobday. I'm an associate solicitor at 1 Dickinson. My specialist area is it's a mixture of residential property litigation, both contentious and non-contentious, involving possession proceedings, injunctions, as well as asset and property management involving day-to-day tenancy and leasehold management. I also deal with due diligence on large-scale acquisitions and disposals, and also residential development work.
Excellent. Thanks, Jason. Yutunde?
My name is Yutunde Dania. I'm a partner at Trowers and Hamlins, as you may have guessed from my backdrop. I have 25 years experience in dealing with residential landlord and tenant disputes. And for the last 20 years, I focused predominantly on litigation on behalf of landlords, both large and small.
Excellent. Thank you. Rebecca?
Rebecca Francis. I'm in the real estate disputes team at Osborne Clarke and predominantly advise clients in both the student and BTR arenas on asset risk management and ultimately any disputes that crop up on mixed use premises, and that's whether it's landlord tenant or development issues. And I just was going to have a real shameless plug here, but OC, we're just about to release a research piece on alternative resi in the mainstream, which the UKAA have fed into, so that's being published this week. So
sorry, when did you say it was being published?
It's being published today on Thursday, so I think that will come through the UKAA as well.
Fantastic. We look forward to that. Thank you. So, Carl, thank you.
Hello, everybody. I'm Carl Anders from Walker Morris. I'm a partner at the firm. Like Yutunde, I've been at the firm for 25 years, and I head up a team of housing management and litigation lawyers, 6 of us doing that work, advising both public and private sector landlords.
Sean, we had some problems with you, but I've just realised in my first actual webinar, I've chaired lots and lots of meetings on Zoom, but I've never actually done a webinar. I've just realised that I actually have control over all of your microphones as well. So Sean, can you hear us?
Yeah, I'm with you now, having switched devices. That's okay. So I'm Sean Elson. I'm a partner in the Pinsent Masons Health and Safety Regulatory team, and I take the lead on issues with our business on CDM 2015 and the building safety agenda, as well as the more general health and safety stuff, and particularly as it applies to COVID-19, etc.
Excellent, and there is certainly a lot of aspects that we're needing to consider on health and safety at the moment. So Matthew, lastly to you.
Hi, good afternoon. I'm Associate Director at Osborne Clarke in Bristol. I'm a member of our regulatory team with a specialism in health and safety, so do work closely with my real estate colleagues on all aspects, really, and increasingly, as Sean's already sort of alluded to, there are quite a lot of changes afoot in building safety with the recent bills and post-Grenfell as well. So there are changing times ahead, which we'll be advising.
Excellent, thank you very much. Okay, so we're going to go into the first section. This is around possession proceedings in the face of Coronavirus Act 2020, which came in, I think, was on the 25th of March, if I'm correct, maybe the 24th. And the first topic, Yutunde is going to just discuss the moratorium and other changes that are here now. Over to you, Yutunde. Sorry, Yatunde, I think you, yeah.
I've got it. So the moratorium came into force on the 27th of March. I'm just trying to get my notes up, sorry. So yeah, came in on the 27th of March. We now have a new practice direction, 51Z. So this practice direction is a new one in relation to the civil procedure rules. And it ceases to have effect from 30th of October. So the impact of this new practice direction has been massive. Basically, it means that any cases which are currently in the court system or about to go into the court system, so for example, if you've just sent off your claim for possession to the court, it basically means that those cases cannot progress to a stage where somebody is going to be evicted. And on the backdrop of Corona, it's quite obvious why. The whole objective is to ensure that people are really kept off the streets and don't have cause to put additional burden on local authorities by going to them to seek emergency or temporary accommodation. So the moratorium is in force initially for a period of 90 days, so until approximately the 25th of June. However, we all need to be aware that this initial period can be extended. So it applies to all possession proceedings. So those are proceedings pursuant to Section 8, so your general rent arrears grounds or breach of tenancy, or if you're going down the no-fault possession ground route, Section 21, and those provisions are both of the Housing Act 1988, which you'll most likely be involved with. It also impacts licences protected by the Protection from Eviction Act. The good news is that landlords can still apply for injunctions. So, for example, if you have a tenant that's failing to provide access so that the gas safety inspection can be carried out, or an electrical safety inspection can be carried out, then you can still apply for an injunction. And similarly, if there is antisocial behaviour. Hot off the press is that yesterday the practice direction was amended to include a new paragraph 2A, which confirms that the suspension of possession proceedings does not apply in relation to squatters. So if you have squatters in your properties, then you can still pursue possession against them. Leslie's mentioned the Coronavirus Act. This was rushed through Parliament in that it received its first reading on the 19th of March. It received royal assent on the 25th of March and came into force the next day on the 26th of March. In relation to this piece of legislation, of particular interest is Section 81 and also Schedule 29. These are important because they increase the notice period where a notice seeking possession is being served, either due to Section 8 or Section 21. So the position now is that rather than if you have a rent arrears case where normally you'd give 2 weeks notice or 2 months notice is given where you're relying on mandatory grounds 8, you must now give a total of 3 months notice. Similarly with Section 21, you'll be very used to be giving 2 months notice. Again, that requirement now is to give 3 months notice. If you are thinking about serving notice at this time, it's very important that you use the new prescribed forms. So there are new forms 3 in relation to Section 8 and 6A in relation to Section 21. These forms were updated on the 26th of March. So if you have served a notice without using these forms since that date, those will be invalid. It will be necessary for you to reserve using these new forms. The forms, as always, can be obtained from gov.uk, the gov.uk website. It's important that you use this website because, for example, Form 6A having been amended on the 26th of March, has already been updated and amended again on the 3rd of April. So just be aware that the documents are constantly being updated, or there's the potential for that to happen. You should also be aware that these forms have to be used until the 30th of September of this year. So by way of summary, you can still serve notices seeking possession in relation to Section 8 or Section 21 using the new forms. You can still issue proceedings, but you need to be aware that if you go ahead and issue proceedings, those proceedings will then be stayed due to the new practice direction. And also, where any hearings have been listed already, it's likely that you will receive correspondence from the court telling you that your case has been adjourned to a date in the future. You're unlikely to be given a new date, and the court will advise you, don't contact us, we will contact you with a new date.
Thanks, Yutunde. Could I just ask a practical question? You said that that possession can still go ahead because of health and safety breaches and antisocial behaviour. But then my question would be for operators would be around actually those possession proceedings in terms of the court actually processing those sorts of things. Where are we at with that? Is everything on hold?
So in terms of those, it wasn't possession. In terms of access and gas safety,
right, okay,
those are injunctions. So the court is still dealing with those.
Okay.
We have recently issued one. Unfortunately, we've been given a date of the 9th of July, whereas ordinarily we expect to see a hearing date within 2 or 3 weeks. So I think we're very much in the hands of the courts in terms of when they are listing those matters. But I'm sure one of my colleagues will tell you that from the health and safety perspective, once you've done everything you can by issuing those proceedings.
Yeah, and sorry, thanks for clarifying that. I think from an operator's perspective and the practicalities of these sorts of things, health and safety is definitely one thing, and doing everything you can, and proving that you're working towards that is obviously evidence and protection against obviously further risk. One of the realities is around antisocial behaviour and people who are in sort of things like domestic violence, and where we as operators, you see the coalface of some pretty serious incidences. And I'm just sort of slightly going off track, but I do think it would be of interest. What can people do in those circumstances to address those sorts of scenarios? So is injunction the only way that can happen, and how do you accelerate that if that's already being delayed?
So in terms of injunctions, if there was a situation where a landlord felt compelled to apply for an injunction, and obviously injunction for private landlords is slightly different in that there's no power of arrest, but certainly what we're finding is that the courts are, in fact, the couple that I've dealt with, the courts haven't even listed the matter for hearings. They've read the papers and issued the injunction orders, and then listed the matter for a further hearing. So the courts are dealing with, every day they publish what they are dealing with in terms of priority 1 work, which must get done, and priority 2 work, which is the work that should get done. And invariably, injunctions are in the priority 1 category.
Okay, and just to finish that topic up, are these proceedings in courts going on virtually or in person? What's the practicalities?
So it very much depends. The nature of, I think the court's perspective at the moment is that all cases should be dealt with remotely where possible. But of course, with defendants, that's not always possible. So you could face a situation where the court is minded to deal with the matter face to face, but other than that, it's by telephone or by way of video conferencing.
Okay, great. Thanks very much. So moving on to the next point that we had, it was, Carl, you're going to cover the anticipated pre-action protocol and what we might be expecting to see. You're on mute.
You know, if I'm coming through loud and clear.
Yep.
Good. Okay. So yeah. So the anticipated pre-action protocol. Now the context here is we do have a protocol for social landlords at the moment, so in essence local authorities and housing associations. However, the government's given clear guidance that that is going to be extended to the private sector to protect private renters. So the government's flagged this in its non-statutory guidance that it issued at the end of March. It's a 21-page document, but on page 10, it says we will ensure that private sector landlords reach out to tenants to understand the financial position they're in before taking possession action through the courts once the 3-month delay on issuing eviction proceedings has ended. And it will encourage landlords and tenants to work together to agree an affordable rent repayment plan if tenants fall into arrears. So the focus on the government's message is on rent arrears. The current pre-action protocol that applies to social landlords not only covers possession claims based on rent arrears, it also covers other types of possession claims, which would include Section 21 notices. And I'll come back to that shortly. In the meantime, you might ask, what's the aim of a pre-action protocol in the context of court proceedings? Well, in general terms, they're there to encourage pre-action contact between the parties and avoid litigation via settlement if that's possible. So what does the existing protocol say in respect of rent arrears possession claims? Well, it expects a landlord to initially contact a tenant who falls into arrears. And when doing so, the protocol states there should be a discussion, and that discussion should cover the reason for the arrears, the tenant's financial circumstances and any entitlement to benefits, and the terms for repayment of the arrears. There should then be an agreement to an affordable repayment schedule, which the landlord should then go on to set out in correspondence. So far so good. That seems like a fairly common sense and pragmatic approach to take, particularly in the current circumstances. However, the protocol that we've got at the moment goes beyond that, and it places further burdens on landlords. For example, it states landlords should assist tenants with benefit claims and effectively delay taking any further action where such a claim is being processed. It also says landlords should signpost tenants to the CAB and debt advice agencies where it appears the rent arrears are part of a wider debt problem, which I guess is going to be the context of the post-COVID world. In addition, it also says that once you've served a Section 8 notice, there should be a further discussion between the landlord and the tenant with a view to avoiding court proceedings. So it does, in summary, require quite a bit more perhaps than what's currently being done in the private sector. So that's the gist of the protocol in respect of rent arrears. There's nothing specific being said by the government in relation to extending the pre-action protocol for Section 21 notices, for example, which is a mandatory ground for possession. But we'll have to watch out and see if the government intends to extend the protocol to those types of claims as well. If it does, then it's just worth noting that in the existing protocol, if you're running a Section 21 case, at the time that you serve your Section 21 notice, you are supposed to consult with the tenant and tell them that you're seeking possession and invite them to ask you to take into account any personal circumstances of theirs before deciding to proceed and recover possession. So there's an extra layer of consultation, if you like, in the context of Section 21 cases. So we'll have to look and see if the government introduces that as well. So that covers what the existing protocol expects from social landlords, but we ought to consider what the implications of non-compliance with the protocol are, bearing in mind the intention to extend its ambit to the private sector. So if you look at the protocol at the moment, it says that if a landlord unreasonably fails to comply with its terms, the court may, I stress may, make an order for costs against the landlord and or adjourn, strike out or dismiss the possession claim. They're obviously potentially serious scenarios. So bearing that in mind, what should private sector landlords and operators be doing in anticipation of the protocol's introduction into the private sector? Well, first and foremost, stay tuned into further developments as the detail of the government's intentions needs to be rolled out. In the meantime, the terms of the protocol should be reviewed, particularly in the context of rent arrears. I think there's a very strong prospect that these arrears specific protocol requirements will be rolled out to the private sector. So any existing arrears policies and processes should be considered to see how closely they're aligned with the protocol at the moment. Bear in mind the government's repeatedly emphasised in recent weeks that there must be dialogue between landlords and tenants when the latter are in financial difficulties. It's therefore important that these conversations do happen and they're recorded and kept as a record of what was discussed and agreed. So once we know what the exact protocol requirements will be, I think checklists will also be a useful tool to incorporate as well, both to ensure protocol compliant policies are followed, but also to evidence that in the event that there are future court proceedings. So in summary, the protocol is not yet applicable to the private sector, but that's the direction of travel. And whilst compliance with it is only advisory rather than a mandatory statutory requirement, what you've got to remember is the rub lies in the power of the court to look into whether it's being complied with. And remember, the court has carte blanche to dismiss the proceedings, adjourn them to ensure protocol compliance, make an adverse order for costs against the landlord. So I think we do need to take it into account and plan ahead.
Excellent, thank you, Carl. And that's a really interesting direction of travel in terms of well, effectively satisfying a protocol, which isn't law but it is recommended, and actually how, you know, when would it be satisfied, and how do you demonstrate that, particularly in the private sector, as this hasn't raised its head before, and the reflection, what seems to be the reflection of the social sector moving more into the private sector. And I think in the build to rent world, this would be seen as already good practice in terms of liaising with residents, coming up with good payment plans. That just is best practice, and we would do it anyway. I think to make it mandatory and to dictate to a sector that's already performing well, maybe sort of taken a little bit abruptly, but definitely one to watch, and I'm sure that we'd be interested in updates as that progresses. Just moving on to the next topic that Anna is going to cover. So the other options available, Anna, what can we do when facing a breach? Because obviously one site doesn't fit all.
It doesn't, and thank you for that introduction. I think it's important that, you know, obviously Yetunde's touched on the moratorium and how that is impacting on us right now, and Carl's given the overview on the practice diary with the anticipated pre-action protocol and the steps that you can be doing to assist yourselves now. Those are really good lessons to take on board, like he said. And I think, you know, there is a lot of confusion about how the government is proceeding, and until the recent clarification on the amending practice direction that Yetunde touched on, we were all considering the prospect that when we had trespassers, we were going to have to seek injunctions to get trespassers out of buildings. So that's a really, really useful and helpful clarification that has come through recently. So yeah, I'm quickly going to take us through the other options that could be available if you're facing issues other than the need to get possession of your properties, and in some cases in anticipation of this action that you might have to take in the future. You know, we're all in this period of further lockdown where it's looming, and how are we going to deal with things beyond? So facing these additional issues from tenants, when we can't seek possession, what else can we do? As you said, Leslie, there is not one size that fits all operators. There's not one size that fits all tenants. Every situation is different. But regardless of the issues, understanding how you might want to tackle those breaches is important in terms of process, warning systems, potentially implementing the checklist that Carl's talked about. So you know how you might want to escalate matters and what resources you'll have to your hands to help with that, and also to factor in the reputational concerns that you might have about taking certain steps. So I think there's a couple of categories to consider. The first being rent arrears, and that's going to be high on people's list of concerns right now, is the cash flow coming into the business. So you might actually have situations where you have tenants who aren't paying their rent and have not made any attempt to engage with you to reach some kind of payment arrangement. And obviously that is encouraged in different sectors. But, you know, for the want of a better word, you might have some tenants who know what the government has done in terms of the moratorium and are basically chancing their arm and thinking, I'm not going to pay. I have the means to pay, but I'm not going to. And they don't talk to you about that. I think genuinely most tenants want to talk to their landlords about their situation and resolve things. But if you are facing a situation where there isn't any engagement, you know, a debt claim is still a possibility. And that is an action which would help you secure a judgment for the payment of those monies. And it can be done relatively easily online. The cautionary point with that is that you will be spending money on legal fees, court fees, and in some circumstances, enforcement can be really difficult and time consuming. And also, you know, realistically, if a tenant is truly in trouble, they're not going to have the means to pay, even if you do get a judgment. But in some circumstances, the threat alone will be enough to motivate tenants to at least talk to you and agree some kind of payment plan if they can evidence that they are genuinely in trouble. Like I said, some of them might be chancing their arm, and there might not be a lot that you can do until this moratorium on possession proceedings is lifted. But, you know, ultimately you have to think about what kind of money you would want to spend to pursue this, and also whether there is a you know, some message that you need to send to people that you're not willing to allow this kind of behaviour to continue. Another arm of that is the bankruptcy process. That has obviously got reputational issues, particularly at this kind of time where we are dealing with unprecedented circumstances, as to whether you would want to do that. And also the practical side of it, that it does require a statutory demand to be served and arrears to have accumulated in the sum of at least £5,000. So for a lot of tenants, that will take time to accumulate. And by that point, we may be through the moratorium period termination, and possession may be the most straightforward way, particularly on a Section 21 no-fault ground, just to get rid of the tenant and basically write it off as a bad debt. And like I said, reputation with the bankruptcy side of things, given the tenor of where we are, would be a factor really to consider in those circumstances. Turning to other breaches, and that's, by that I mean non-monetary breaches of the tenant's tenancy. So this could be anything like their obligation to keep the unit in repair, or to adhere to regulations, to causing a nuisance. And the remedies available here are the same as they've always been, but it's worth considering, you know, the circumstances that we all find ourselves in, and particularly in a kind of big residential block. You know, we're all at home, we're all there at the same time, and for a sustained period. There's likely to be issues cropping up that you wouldn't have experienced before, simply by having a higher volume of people in their properties at the same time, and this wouldn't have occurred before lockdown. So in many of those circumstances, having a management process to resolve those issues, so reporting, discussions with tenants, and a warning system or a checklist system will likely do much to manage and diffuse those kinds of situations. You know, for example, people will need to adjust to the new normal. What does it sound like to be at home when people have got kids at home, or playing music, or doing their exercise videos? That is just, you know, this is how we're going to be for the time period. And just because it, you know, might be something that you're not used to, it doesn't mean it's actionable. You just might have to get used to those noise levels, and a lot of that can be dealt with through management. But if there is a nuisance, or there are clear issues with antisocial behaviour or breaches of the government lockdown guidelines, what can you do? So if those management approaches have failed, your most effective resource could well be the police or local authority officers, who might well intervene in those circumstances. And you know, I think we've all seen in the news that the police seem very keen to help in situations where there are perceived breaches of the lockdown measures. And, you know, they ultimately have, you know, fining powers, power of arrest. Again, there's a reputational side of that, but ultimately if people are causing problems and distress, you may need to call them in. Those kinds of powers and resources aside, you can still issue your Section 8 notice, citing discretionary grounds like breach of tenancy or antisocial behaviour and nuisance, but obviously we're subject to new prescribed notices, new periods for termination, which means we're still in the process where these things will take time because they're subject to the moratorium. But it does send a warning to the tenants that you're not willing to take these kinds of issues lightly. But yes, bearing in mind that there is going to be a delay on the notice period, on seeking possession, and there may well be an administrative delay once the doors and gates are finally open on possession proceedings. There's going to be a huge amount waiting to be dealt with. But at least we know now that proceedings can be issued. I think we've all probably seen that, you know, we've issued claims and they haven't actually been issued by the courts, but the amending practice direction has clarified that those proceedings should be issued. But ultimately, if there is an actionable nuisance, you can apply to court for damages and an injunction to either restrain the nuisance or to you know, as Yatunde said, if you need for something to happen on a unit, you can force that. It again may take time, it's costly, and you know, but sometimes the threat of just undertaking that kind of action can get things moving. If you're looking at something like a breach of repairing covenant, so there's been damage to the unit, or you know, I think the first point of recovery would always be the deposit at the end of the term. But there could be circumstances where there's been significant damage that you need to look at, or there's been some kind of health and safety issue that you're concerned about, and that will need to be dealt with, and that would need to be dealt with proceedings. I think we've touched on a little bit in terms of the courts and the practicalities of actually bringing court actions, and the messages that I think we're all being given is it's business as usual. The court is really embracing technology. They want to, you know, use whatever technology is available to them. We've seen Skype hearings, Zoom meetings, you know, everybody's filing e-bundles. It can happen and will happen if everybody's got a will, but equally there has been a flurry of time extensions and the court seems amenable to that as well. So again, one size doesn't fit all. You need to look at what's right for your team, but also your claimants and defendants, what's right for the circumstances. So each case is different. In terms of practical issues and practical steps, I think we've touched on them. It's just talking to your tenants, knowing your customers, working through them. This is a period of unprecedented strain on people and their resources. And it seems like from the feedback that we've had, most tenants, if they are in trouble, are willing to talk to you and willing to work it through. And that has got to be better than proceedings ultimately. But, you know, there will be circumstances where, you know, there are people who need dealing with, and there is the ability to work through that. Escalation processes might assist, so working on a stage basis, you know, using management discussions as the first stage. Second stage, if that kind of management intervention doesn't work, using official warning systems. And then really, if it's really not going the way that you want it to, looking at those kinds of interventions that I've touched on. So using the police, using the local authority, and legal proceedings if you really need to. Just to reiterate, one size doesn't fit all. All circumstances are different. You know, I'm sure you've got people who will help guide you through those different circumstances. But I think flexibility is going to be the most important driver at this stage to work through those issues, because we don't know yet what's coming in the next weeks and months. And I suppose that takes us touching neatly onto the next section, which is to look at the management during lockdown.
Thanks, Anna. That's really helpful and very insightful. And I think that flexibility and using the tools that you have at your disposal for immediate effect is very important, because actually some of the things that members will manage, particularly in terms of as operators, is reputation. And reputational damage or reputational protection is probably third on the list. So as operators, management companies, our primary responsibility is to protect persons and property, and very closely followed by reputation. They tend to go all hand in hand, because that is obviously quite important from a sentiment point of view, and as a response, positioning yourself as a responsible landlord. And a lot of our landlords are listed, drive a share price, and therefore are very concerned about their reputation. So that's another big topic, but we'll move on to the actual practicalities of managing your residents and staff during lockdown, and those obligations and duties. And actually, Jason, I think you're going to cover repairing obligations. So over to you.
Thank you. So during the lockdown, landlords will their maintenance and repairing obligations, both under the contract and statute. So Section 11 of the Landlord and Tenant Act 1985, it essentially remains unchanged during the lockdown period, as does the tenant's obligation to allow access. But obviously we need to have regard to what's going on at the moment. It isn't that black and white. So landlords will nevertheless have to take account of the Public Health England guidance, and also its duty of care to its tenants, their households, as well as its employees and contractors. So they need to be alert to the risk that someone in the household is vulnerable, is shielding, or is self-isolating due to symptoms of COVID-19. And in light of all that, I've got to obviously try and discharge their repairing obligations accordingly. So staff and contractors mustn't be going into properties if they are displaying even the mildest of signs of COVID-19. The government has issued guidance on the issue about accessing properties and carrying out work in people's homes during the lockdown. The government's guidance indicates that work carried out in people's homes, for example, by tradespeople carrying on repairs and maintenance, can continue, provided the tradesperson is well and has no symptoms. Again, it will be important to ensure that Public Health England guidance, including maintaining a 2-metre distance from any household occupants, are followed to ensure everyone's safety. No work should be carried out in any household which is isolating or where an individual is being shielded, unless it's to remedy a direct risk to the safety of the household, such as emergency plumbing or repairs, or whether tradesperson is willing to do so. So no work should be carried out where a tradesperson who has coronavirus symptoms, however mild. So that's a summary of the government's guidance on this. So, I mean, how can landlords ensure they are discharging their obligations, their repairing and maintenance obligations, whilst trying to comply with that guidance, and also keeping one eye on the health and safety of their staff and tenants in mind? I think first and foremost, they should really be getting down to the basics and providing staff with hand sanitizers, gloves, PPE, so masks, and insist that any contractors that you employ as well are adopting the same. They should ensure staff and contractors understand the Public Health England guidance, particularly on self-distancing and reducing the risk. So as an example, when they're attending properties, they should be thinking about opening windows, so allowing good air ventilation, regularly washing hands and using hand sanitizer, particularly when they're coughing or sneezing, and also having and using the appropriate PPE. Landlords should also look at a risk-based approach. So each property really should be considered on a case-by-case basis. So they should really be asking whether, in advance of a contractor or a member of staff attending at a property, they should be having a dialogue with the resident to find out whether the tenant is self-isolating as a result of possibly having some COVID-19 symptoms, and then reacting appropriately where they find out they do. So where a tenant is self-isolating, but as an example, the work is not urgent, the landlord and tenant should agree a date once the 14-day period is over. Where the tenant is self-isolating, but the work is urgent and therefore poses a risk to the health and safety of the tenant, or a risk actually to the property, and so really can't wait for the 14-day period to be up. The landlord should try and have a dialogue with the resident about agreeing an appropriate strategy to be able to have a tradesperson attend, but whilst also minimising the risk to the residents, to the household, and also to the contractor. So where we're talking about something that is urgent and is a health and safety risk to the resident, we should obviously be suggesting that whether it's an appliance or it's a supply, that they should essentially turn that off and wait for the tradesperson to attend in order to resolve the issue. Also requesting that when the tradesperson arrives, the household essentially removes themselves to another room where so that the work can be carried out without the household being in close proximity. Again, windows being open to improve air circulation and the increased use of personal protective equipment to be worn by the tradesperson. You may also find that there are going to be some tenants and households that are not self-isolating, and so don't have any symptoms, but are just a little bit paranoid in respect of self-distancing guidance and are perhaps adopting quite a strict approach to that. I think in those circumstances, again, you need to look at what the issue, what the repair is, whether it's urgent or whether it's actually fairly standard. If it's standard, perhaps we can put it back to a more appropriate time. But if it's urgent, I think you've got to get in there essentially. So if the tenant is refusing to allow you access, I think that's when the landlord might not need to start a dialogue of advising the tenant what their obligations are in respect of access, and start thinking about escalating the options if the tenant continues to refuse to allow access, because ultimately we are wanting to get in there for the purposes of health and safety or protection of damage to the property. So where the landlord is unable to gain access, i.e. there's persistent refusal by the tenant to allow access, whether that's because the defendant's vulnerable or shielding or self-isolating, the tenant and the landlord should essentially agree a date for the work to be undertaken, and the landlord will need to be able to evidence that at a later date and to demonstrate what reasonable steps it has taken. So really it should be thinking about making sure it's got a paper trail, so keeping records of communications with the residents, and also records of details of attempts by the landlord's engineers or contractors to try and gain access as well. So that helps hopefully build a body of evidence if there are problems later down the line. If the works are so urgent that we can't wait for self-isolation period to be over and the tenant continues to refuse to allow access, notwithstanding the urgency, I think the landlord is going to need to really think about escalating it further and may need to consider an application for an injunction to allow access. So Anna and Yatunde have touched on this already, so I'm not going to cover that old ground, but ultimately an application for an injunction to require the tenant to allow access is where you would probably need to end up. So must also not forget that a landlord may be struggling with reduced repairs and maintenance offering because essentially the staff or contractors might themselves be self-isolating, or we might find that some of the contractors we're using are folding. So where this has happened, landlords are essentially they are going to need to find alternative arrangements as quickly as possible, and obviously ensure that those contractors are following the Public Health England guidance and your own requirements when it comes to the use of PPE and self-distancing. So where resources are limited, normal maintenance repair services can't be provided, landlords are obviously going to need to take a strategy where they are prioritizing work based on the levels of risk that are posed by the problem, the impact on the tenant of not completing that work, and also other factors such as the age of appliances, the previous work that's been carried out, the breakdown history, and whether also the tenant is considered vulnerable. So a word of caution, however, is that whilst landlords are likely to be seeing reduced rental income and therefore are probably going to be perhaps putting to one side or deferring current or future discretionary capital expenditure programs, such as cyclical replacement or improvement projects, landlords shouldn't really be treating minor repairs and maintenance in the same way. Improvements are not a statutory or contractual obligation, whereas repairs and maintenance are. So failure to discharge your obligation will result in landlords being in breach of the contract, and also Section 11 of the Landlord and Tenant Act 1985, and so the landlord could find itself potentially at risk of a damages claim in the future. So we need to get in to do the work. One final thing to consider really is also whether deferring repairs and maintenance could invalidate any insurance policy. So I think it's worth landlords having a look as to whether there is a risk of insurance being invalidated if we're not carrying out the work. I think once lockdown is over, landlords will need to ensure that the backlog of outstanding works are dealt with as quickly as possible. And obviously with limited resources and perhaps contractors not being available, this might be difficult. So we're really going to need to look at prioritising the most important parts of the work first, the most urgent first, and then dealing with the more day-to-day repairs and maintenance thereafter, but as quickly as possible ultimately. So that covers that.
Thanks, Jason, and that's really interesting, also in line with the fact that the HSE is not letting up on obligations on landlords to fulfil and discharge their obligations for inspections of anything, which of course has also led to a conversation which I think has been topical around insurance, particularly for lifts and LOLAs, lift inspections, and insurers like Allianz and Zurich not covering people to inspect their properties from an insurance point of view, and then not covering landlords when they don't do their inspections. So, but fortunately the government and Allianz and Zurich have all seen the light, and that issue has now been resolved, but it certainly came up. Just in regards to regulation requirement, Rebecca, you're going to cover about electric gas EPCs on new lettings.
Yeah, of course. So just following on quite nicely, I think, from what Jason discussed, looking at a reminder of the key regulatory obligations and how they're impacted by lockdown. And as Leslie said, gas, electrics, EPCs, just very, very briefly, and ultimately right to rent, which is slightly out of that repairing realm, but I think it's still important just to remind ourselves where we are. For all of those, ultimately the obligations are still there, lockdown or not, but the government has brought in some temporary assistance measures in respect of right to rent, and I've seen that the National Residential Landlords Association are calling for the government to suspend the requirements on gas and electrical safety certification for 6 months. So much like what the government's doing with MOTs, calling for a similar moratorium on this, and perhaps delaying, your annual checks from 12 months to 18. So I think, as with everything we're discussing today, we're just going to have to keep an eye on it. But this is, as I understand it, the status that we're in. So, for those buildings with a gas supply, just a reminder that you have to have a valid gas safety certificate on grant of any new tenancy, and carry out annual checks. So, separate from any sort of health and safety enforcement issues, the current state of authorities on this, and we are waiting for an important appeal to be handed down, but I haven't seen it today unless anyone else on the panel has. Essentially, it says that a failure to provide a gas safety certificate at the outset of your tenancy, and perhaps a failure to carry out any of your annual checks, will preclude landlords from serving a Section 21 notice. So it essentially converts it into more of an assured tenancy. I think that sent some shockwaves through the industry when that came out. So again, we need to watch that space. I appreciate that maybe the Section 21 piece may not be quite as critical during lockdown, but it's about future proofing if we are actually granting tenancies now, which I understand people are. So again, just reiterating what Jason said, landlords really do need to try their best to get, gas safety certificates done and inspections carried out where possible, but you've got to take into account all the self-isolation piece Jason discussed and availability of engineers. I think I even had someone saying that an engineer they were trying to get in said they couldn't get their up-to-date, keep up to date with their professional certification to be able to then come out. So even if they wanted to, they were struggling to tick the boxes at their end to be able to do it. So it's this sort of domino chain effect. And again, just leave it, you have to leave a clear paper trail of your attempts to find an engineer to try and get access and just log any replies. And I think one would really hope that, especially in terms of possession proceedings, again, not health and safety enforcement, a court would hopefully take some of these circumstances into account, but I would be wary of certainly granting new tenancies without gas safety certificate until there's some further guidance on it. Electrical safety, so these were some new regulations that came in March, which essentially from the 1st of July, it says private landlords have to provide any new tenants, and that's so any new tenancies granted from the 1st of June this year, with an electrical safety inspection report for the unit. I think thankfully for existing tenants, so tenancies that were granted pre 1st of June, you don't have to retrospectively inspect until April next year. So I very much hope we're not in lockdown by then and we're not discussing logistics. But again, as it stands now, subject to availability of available qualified electricians, you would hope that if you do have to comply, an inspection could be carried out on vacant units within government guidelines, but I appreciate there's lots of logistical issues there that Jason talked about as well. EPCs, and correct me if I'm wrong, I felt that there probably wasn't something to focus on too much, because I'm not sure it's going to be a real an issue for live BTR schemes, because I would have expected that they would have been commissioned in the last few years. They only have to be refreshed every 5 years. And there's probably different considerations around building rather than unit access. So again, it's just remembering that you do need one if you're going to be letting, and I think it's just a matter of doing sort of an audit on your sites if the regs apply, to check when dates are coming up. Finally, just on right to rent checks. A reminder that again, on any new letting, you have to check the immigration status of any intended occupier, so not just named tenants. And if it transpires that they have only a time-limited right to rent, the checks have to be carried out again. I know we've had lots of roundtables on the joys of right to rent, and so most will be familiar with the very stringent requirements around checking and certifying original identification documents. And obviously that's the biggest challenge during lockdown. So the government sort of offered a bit of an olive branch by announcing temporary relaxations. And what they've said is that tenants can send scanned documents or a photo of documents for checks using email or a mobile app rather than sending originals. And checks can now be carried out over video calls. So you have to get your tenant to hold up their original documentation, and you'd have to cross-check it against the scanned version that was sent over. But crucially, give with one hand, take with the other, retrospective checks will need to be carried out within 8 weeks of the COVID measures ending. And the government will advise when the measures have ended. But you would have to check the originals. You need to keep a record of both checks, and there's some prescribed wording that needs to sort of go with it. And obviously, if it transpires on the retrospective checks that they never had a right to rent, you'd have to take steps to terminate the tenancy. But for me, I mean that seems to fall into the category of It would only be if it transpired that they were forged documents on that would be an issue, because if the documents are genuine on the scanned copies, you'd be able to see if they've got a permanent right to rent or a time limited, and you just need to diarise those checks. So I mean, I can't see that being a big issue. And I know lots in the BTR, they would outsource that anyway, so not a direct issue for landlords. And that's all I really wanted to say.
Okay, thanks, Rebecca. That's sometimes landlords outsource it and sometimes they don't, but it's a valid point. And actually, I didn't know about the retrospective checks, so that's quite interesting. I do actually have a question here that might be considered when Matthew covers the next section around health and safety considerations during lockdown. I know you've got your notes to cover, Matt, but I'm curious also in regards to when we've got these regulations around gas, electricity, and that's all statute, that's all fine. An anomaly with this whole thing is, one, it's around cleaning. So when people are moving into a building, into a new apartment, and someone's moved out, the obligations around the property potentially being contaminated or not. And there's something thinking about future pacing, and also liability in that regard, because we talked about repairing obligations and contractors going in and out of properties and all this kind of stuff. And it struck me that it might only be a matter of time before somebody decides to sue somebody because they got infected by purportedly somebody. Now that may be a whole topic of its own, and I'm not quite sure if we're ready to cover that, but maybe Matt, just in your regards to what you're covering in health and safety, if you could, if you haven't already considered it, just that that cleaning piece, because that on a practical level for our people and our members is really important.
Yeah, certainly. I mean, I think that's going to be very relevant coming out of post-lockdown as apartments start to change hands. I mean, there will be an obligation in the sense that there is, you owe that duty of care, and you owe that duty under the health and safety legislation to ensure that those affected by your business, which the business of renting out those apartments, doesn't impact on the health and safety of those who can be affected. You have to control those risks to a level that's reasonably practical, and I think cleaning will be one. I mean, I think on the liability point, sort of straying into civil there, it's going to be quite challenging for somebody to demonstrate that the cause of their infection was attendance at that particular apartment, or it wasn't sufficiently clean. So I actually probably think the liability risk is quite small, but there's not least a sort of reputational point, in terms of saying that you've done all that you can. But and I also think it's unlikely the health and safety executive would be looking at those aspects unless there is something very specific on the circumstances to do with somebody who's been infected in that flat, and it's all well known. But I think post lockdown it's absolutely something that should be considered. I was just going to talk briefly about a couple of areas I think are important during this unique period for discharging health and safety obligations. One is just to build really on what's already been said about thorough examinations, testing of equipment, inspections, specifically those that have a statutory basis, and also just managing some specific COVID-19 risk to employees and tenants. I think this has always been mentioned, turning to examinations, for example, lifts, gas, electricity, fire protection systems. The key point is that COVID-19 has not trumped the legal obligation. The legal duties remain as was. And despite the stay-at-home message, duty holders and inspection bodies must cooperate to ensure access to plant and equipment for statutory thorough examinations and other legally required testing. So the Public Health England guidance on social distancing, it's not an automatic barrier to doing that work, just as it's not an automatic barrier to doing any essential repair works, as Jason touched on earlier. The HSE have produced some guidance and have stated they'll adapt a pragmatic and proportionate approach towards enforcement action for non-compliance with statutory requirements which are directly attributable to COVID-19. However, if I'm honest, I think that broadly reflects its normal enforcement approach, and we probably may all be aware of examples of the HC being somewhat less than proportionate, often depending on the whim of the particular inspector involved. However, if a duty holder can demonstrate it has used its best endeavours to get an inspection or conduct necessary safety testing, and if it can't do so, show that it's adopted a risk-based approach, then it is likely to be acting reasonably in the circumstances. However, not testing will not be expected to be the norm. So what does this mean in practice? And the very first and simple point is to ask yourself whether the relevant piece of equipment or activity is essential for either the operation of the building, or it's essential to safety in itself. If taking that out of use for a limited period the effect is very minimal, then the answer probably is to take it out of service. If the equipment is critical for either operational safety but inspection is not possible due to physical constraints, or as we've touched on, a real issue with availability of inspectors and engineers who may be diverted to other more essential services, then you can consider how you can conduct your own assessment of the safety of its continued use. For example, reviewing past tests, how long ago they were, discussing with users any recurring faults, increasing the number of non-intrusive visual checks, so those things that don't require an expertise, and perhaps rather than inspection, can additional maintenance be provided. However, bound up with that, it is essential that you seek advice from the relevant inspection body or your normal sort of competent engineers and contractors to think about the range of control measures. And as has also been touched on, key is to document the process and the conclusions drawn that show a reasoned assessment of the safety risks has taken place. If engineers, inspectors can come to the premises, and this goes for any contractor undertaking works, there's a duty to consider how to make that interface safe. So a cleaning regime pre-visit, segregating the work area, essential to brief tenants about what's going on, where it is, when it's going to start, and making hand washing facilities available. I think it's also worth mentioning that an ongoing concern will be fire safety, and it's important in this particular lockdown period to be aware that actually the risk profile of the building may have changed. During lockdown, tenants are ever present. Arguably, there is more risk of fires starting due to just a general increase in activity. And that's coupled with often an increase in rubbish building up, people perhaps using communal areas for storage, propping open fire doors as the weather gets hotter. And also there may be areas of buildings that are closed off. They need to be more secure because they become vulnerable to arson. So you have an unfortunate mix where potentially there's a fire risk increasing whilst testing and maintenance is put under a lot more pressure. So I do think it's important to think about how any reduced maintenance provision for your premises could cause a fire risk. If you're the responsible person for the site, that fire risk assessments and other obligations relating to the safety of the staff are reviewed to ensure that you have sufficient staffing levels and people are sufficiently briefed to maintain your procedures effectively. And just to review your risk assessments generally, particularly in respect of those who may still be attending premises as visitors. And finally, sort of very briefly, just on protection of your own employees and visitors and tenants. I think it's important to recognise that whilst COVID-19 is unique, it is like any other health and safety risk. It's something that has to be assessed and the suitable and sufficient control measures implemented. As an employer with control of the premises, you have a duty to your employees, those affected by the operation of the property, so tenants and visitors, to ensure that their health and safety is protected. Any risk assessment prepared should be specific to the premises, the activity involved, and then address the necessary control measures. In these circumstances, as being touched on, it's very likely that a lot of those control measures will closely follow Public Health England guidelines, which is the social distancing and the access to being able to wash. Practically, you just need to think about what the interfaces are. So it may be concierge, cleaning staff, how tenants access communal areas or things like post. And there needs to be some thought given to how you can ensure that there is sufficient physical separation in order to achieve those. So, for example, how delivery is received, where a package is stored, what's the process for collection by tenants. I think it's right that PPE is mentioned, but it's also important not to make PPE the first port of call. It should be about thinking about alternative methods of carrying out the task, even if that requires more time. And then PPE should really form a secondary protection if you can't eliminate or greatly reduce the risk by changing just the way in which you're doing things. And any changes are never going to be effective unless they are really well communicated to both employees, tenants and visitors. And again, document the thinking and controls implemented, keeping their effectiveness under review, and ensure that somebody within your organisation is also tasked with keeping up to date as government guidance eventually changes. I don't think there's anything to really fear from a lot of this. It is genuinely about implementing and documenting just a careful, methodical and comprehensive risk-based approach to these new issues, and just making sure that you aren't just relying on those assessments of risk that you had pre-lockdown, and actually thinking about how the risk profile has changed and what new measures may need to be implemented.
Thanks, Matt. That's really good advice. And this is one scenario where I would say that the legal advice and the operational manifestation actually are quite well aligned, because a lot of operators are quite used to managing risk. It is part of their day-to-day, and triangulating and prioritizing risk mitigation part and parcel of what operators do on behalf of their clients or their owners, because that's essentially what they're employed to do, is mitigate risk. I'm going to jump now to Sean in moving out of lockdown and managing the risk of the new normal, because one of the things that you mentioned, Matt, was really around the balance about resourcing and making sure that from a health and safety point of view that actually you've got enough resource to manage the risk that is presented, and maybe taking more time to do things and so forth. And where there is pressure certainly on the front line to reduce costs because of potentially rent being reduced, and obviously owners are mindful of the benefits of furloughing and things like that, it does actually create that dynamic that could raise the risk profile in these circumstances about resourcing people, the actual supply chain itself, being able to actually make sure that there's enough people, but also when you're on furlough and the minimum requirements for that and so forth. So over to you, Sean, to sort of managing the risk in the new normal landscape and what that might bring.
Whatever that might mean, Leslie. So a lot of this ground has been covered by Matt and Jason earlier in terms of practical day-to-day operational stuff, and I don't want to get bogged down in the weeds of that and just repeat some of what those guys have already talked about. I want, if I can, to talk about some strategic issues and definitely to focus on those things that what should we start thinking about now, because as Jason and Matt in particular were talking about, some of the stuff is really obvious, like we need to get back up to speed in terms of our gas and electrical inspections, building safety surveying, and our LOLA inspections. And Leslie, you touched on the bit of a bun fight that went on early doors around LOLA inspections and how that was causing some practical and pragmatic operational issues. So that stuff I think is just, it's good practice. What I want to focus on are issues such as the ending of the lockdown and the fact that that isn't likely to be an overnight sensation. It's unlikely that we're going to reach a stage, bearing in mind the nature of the virus and the controls that have been put in place, that one morning we'll be told, that's it, fellas, everybody can go back outside now and crack on as we always did. It's going to happen by gradation. And there is also the chance that, having removed some controls, that they might be reintroduced at some point or tightened in some areas and weakened in others. So we're challenged by the fact that we don't yet know what the shape of coming out of lockdown will be, other than I think we can pretty much price in that it won't be an overnight change. Now that for me has real implications in relation to risk management. and strategy and policy and process and the system that you have in place. Because what you need to think about now in terms of safety management systems, which is the fundamental bedrock of complying with your statutory obligations, is it needs to meet the circumstances, and it needs to meet the changing circumstances. So on the one hand, it needs to be robust, and on the other hand, it also needs to be flexible. Now, that's really easy for a lawyer sitting, staring at his iPad to say, but operationally, that's actually quite a challenge. And we need to be thinking about, well, what is it that we used to do? Do we think that that's still adequate to meet the change of circumstances? And if we don't think it is, well, what's it going to look like in the future? So looking at things like, well, what are our frequency of inspections, kind of thing that Matt was talking about. What is the standard we're going to apply, and who are we working with to deliver this? So operators will rely on third parties. So a really good example on this would be when you get back into that stuff that Jason was talking about in terms of repairs and maintenance. So for example, well, that's all caught by Construction Design and Management Regulations 2015. It comes with statutory requirements where it falls within that category of construction works. Well, the people that we've worked with in the past, they understand whether there are new challenges in the way those works are to be delivered, in the way that's already been explored, and how will they meet that challenge? Are they up to that challenge? What will their RAMs look like? What will their construction phase plan look like? Now, again, without getting into the weeds of CDM 2015, which would be a fairly lengthy and boring presentation all of its own, it's just a practical manifestation of saying, well, who are we working with? What are their competencies, and what will we be asking of them? And those are the kind of things that we can be starting to think about now, including any framework agreements that we have with them and scope of services that have been agreed. So, for example, what's the price for the job? And how many people are they going to need to send to do that job? Will it take a lot longer? How are we going to work in putting in cordons and segregation away from our residents or visiting members of the public or concierge staff, etc. So I think for me, that first thing now that people need to be doing is looking at our safety management system and the arrangements that we currently have in place, and are they flexible to meet the new normal, whatever that might be. And as I said, I think that's one of the challenges. I mean, we routinely work with clients in evolving and developing crisis management response protocols. Well, how many of those would have anticipated, a global lockdown and pandemic? Well, my guess would be none of them. That's not very surprising, but it just goes to illustrate the nature of the challenge here. Those kind of unknown unknowns as well as the known unknowns, and how does our safety management protocols consider that and anticipate that? And as I say, competency and scope of service for the people that you're looking to deliver it. The other point that I want to make is that we've talked about enforcement profiles, and I agree with Matt in terms of what is the likelihood of claims, etc., in terms of COVID-19, and what does the enforcement profile look like there? Well, it's not maybe a substantial risk, but it seems to me that in this environment, when you consider that the challenges of inspectors and resources on public authorities, that actually you have hundreds of inspectors. They're the residents and tenants. And as we've seen with things like fire stopping, for example, or fire safety issues within buildings, some of the first people to be jumping up and down saying, this ain't right, you're going to have to do something about it, will be the people living in the building. So if they're not satisfied, that they think your arrangements are up to snuff in the way that these things are done, well, forget what HSE or relevant local authority inspectors are going to be coming and looking at. Your first challenge will be the tenants. It seems to me, and that links into, as I say earlier, fire safety issues, and that I would like to just mention, if I can, on strategic issues, the fact that you've seen that the main message on safety has been there's been very little relaxation of legislative requirements. It's only been on a kind of a nudge and a wink and a guidance around inspections and about gas and electrical safety, etc. Fundamental law remains in place, hasn't been suspended. It won't be for lots of good operational and political reasons. That's also been true with fire safety. And again, I don't expect to see any change there. But where we are seeing change is in the government's building safety agenda. So notwithstanding the lockdown and the logjam within the political decision-making processes, we've seen the fire safety bill, and we've seen announcements from the government that they're taking forward their building safety bill as well, and their building safety agenda. So at the same time as you are wrestling with how do we get back to something like normality around COVID-19, it's also really important not to take your eye off the ball regarding building safety, where you have buildings that are in scope or are likely to come within scope of that building safety agenda. And one part of that that's, I think, really relevant to COVID-19 is the heavy emphasis on tenant engagement. Goes back to some of the things that others have been speaking about, whether it's Carl or Jason, about that kind of spirit abroad of engaging with tenants. Well, that's really important in the context of the government's stated intentions regarding building safety. And it's going to be really important, I think, in relation to the management of this COVID-19 risk going forward. I see those very much as of a piece, and I would encourage people to think of it as such, and also not to take their eye off this building safety agenda ball at the same time as they're trying to wrestle with practical issues about getting back up to date with their gas, electrical and lift inspections and certifications.
Sean, thank you very much for that. We've got 7 minutes or 8 minutes, and I just wanted to, I think our membership and operators particularly are very well versed in the health and safety and regulation, and everything that you've covered has been really interesting across the board from all of you. And it strikes me that the current situation of lockdown is a black and white. Of course, there is some shades of grey in terms of health and safety and making sure that we're keeping people safe, and all of the inspections that we need to do, etc. Working around that, and everybody's given some great tips. Thank you, Matt, Jason specifically. Sean and Matt specifically, in regards to when we go into unlockdown, if you like, and you raise the point that this is not likely to be another, like we just open the gates and everybody goes out. The practicalities of managing amenities in these build-to-rent spaces is that they are communal spaces. And at the moment, we have the Coronavirus Act that sort of protects us from closing those amenities, and if we allow people to congregate, we're actually allowing a criminal offence to occur, breaching statute, etc. When we go into this sort of midway land, we have this scenario which it sounds like the obligation is very much going to sit onto the landlord or to the operator on behalf of the landlord to make sure that we sit and we ensure people comply and act as sort of like a quasi authority in that regard. And that's quite a difficult space to sit, because actually there will be variations of what people think are acceptable, and you'll find that when you walk in the supermarket and I personally go, tut, people aren't keeping the 2 meters social distancing, but someone else is. I'm guilty as well, I'm engrossed in my phone and I forget that I might be standing closer than 2 meters from somebody. So you mentioned the safety management systems, and are they flexible enough to cope with these sorts of scenarios, if you like? But monitoring how many people are sitting in a resident lounge that has capacity for 50 people, and then saying, okay, well, we have to put tape on the sofas. I mean, could you just cover something like that very briefly?
Yeah, I can, and I think that goes back to this flexibility, because there may be some circumstances, and Matt was talking about the process of risk assessment, and really where I'm coming from in terms of having a flexible approach is that a judgment may need to be reached that we can't open that in these current circumstances, because we're not yet at a point, even if some of the tighter restrictions have been lifted. So you might see, for example, some restrictions lifted in relation to public gyms and swimming pools, for example.
Yeah.
But they'll have measures in place to be able to police and patrol those. Do we feel comfortable that we can also do the same? That's why I think there needs to be some flexibility there, because there'll be issues around, well, how would we keep those hygienic, for example? What would be our hygiene arrangements in relation to that? Can we genuinely do it? How do we price that? So that's really where I'm coming from, Leslie, is that there's unlikely to be, a simple, straightforward solution in every case. They'll be lifted gradually. A view will have to be taken by a duty holder as to whether or not they feel in their circumstances that they can reopen that particular amenity, and if so, how they're going to lift it. Are they going to limit numbers? If so, how will they police that? And if they can't police it, well, can we open it at all? But those are the judgments that I'm talking about, and why I think now you think about, well, how do we as a business and an operator, what's our system for enabling us to actually reach those judgments, or are we just going to do it on a day-by-day ad hoc basis, which is frankly where you may end up.
And it's it probably is something that we should spend a bit more time on, and it will evolve as we know what the unlock looks like. But there will be quite considerable concern from owners and operators' point of view, because it will be such a subjective approach and open to reputational impact, if you like, because there will be variations of the from residents who will be impacted by this, because a lot of them pay for a lifestyle which includes these amenities, and in their opinion they want access, or they might take a view that actually that's too liberal, and you're still putting people and persons at risk. So it's quite an interesting topic, and I think that was something that we'll probably want to know more about, because it's the unknown. So that's fantastic input from all of you. We've only got a couple of minutes left, so I wanted to just basically say thank you to all of you. Anna from BCLP, amazing, nice coverage. I've got my notes here. On your section about, the other options available and some of those practicalities. Carl, thank you about that pre-action protocol. That was really interesting. I think that we, as a sector, will watch with great interest any sort of subjective influence that's going to come across from the social sector. It is of a concern, if I'm honest. However, that is best practice already in the sector, and it's done by a lot of people. Yutunde, thank you very much for your section on setting the clarity on the injunctions and proceedings. I think the members will find that really helpful, just to get clarity on that. It's been a question that's come up quite a lot. Just on rent arrears and looking at, Rebecca, you covered a lot about the requirements for repairing, for gas, electricity, and repairing obligations. That retrospective check was particularly interesting. I think that's something that may have just slipped under the radar for quite a few people. And then also, Jason, that repairing obligations around making sure everybody's safe in their undertaking of, as a duty holder, to discharge their liabilities. It's certainly something that's coming up a lot from different clients and different aspects across the sector, saying we want things to happen or we don't want things to happen. So really good to have some guidance on that. Then, of course, the health and safety considerations and what followed on from that. Thank you, Matthew. And then lastly, of course, Sean, just on the unlock scenario. It's been amazing. So, and I think that we'll watch with interest how we do unlock. So Anna Isterton from BCLP, Jason Hobday from Womble Bond, Dickinson, Yutunde Dania from Charles and Hamlin, Rebecca Francis from Osborne Clark, Carl Anders from Walker Morris, Sean Elson from Pinsent Mason, and Matthew Kyle also from Osborne Clark. Thank you so much for your contributions. I do have to also give a shout out to Andrew Yates, who actually brought you all together from BCLP to collaborate on these topics. what we're finding at this time is the information share is of huge value to everybody, and really appreciate your specialism and taking the time to share your insights. I think our member body at UKAA finds it incredibly helpful, and hopefully that they will contact you as and when we do have some build to rent litigation cases, as it might be, but hopefully we might convene again in another session covering some other topics once we sort of move into unlock and the scenarios that that's going to bring around. So thank you very much, much appreciated. And the 30 odd attendees that came in, I'm sure that they've enjoyed it, and no doubt there'll be a lot more people watching after this.
Thank you.
Thank you.
Bye.